My name is Megan Rittle, and I'm a partner here at Smith Welch, Webb and White, and I am joined by another partner,
Luana Ransaw.
And today we're going to be talking to you about the Supreme Court decisions that were handed down this session. As many of you may know, the Supreme Court is the highest court in our country, and so any decisions that come down from our Supreme Court have wide-reaching implications for the entire country. In short, Supreme Court opinions are probably the most important opinions that we get from any court in our country. Usually Supreme Court opinions deal with constitutional issues or laws or regulations that have been handed down by Congress. And so though there are a couple of cases, there are 3 cases in particular that we're going to talk about today that deal with employment issues, and then the DACA, also known as Deferred Action for Childhood Arrivals. So we are going to start with a case called Bostock versus Clayton County, Georgia. And Luana is going to talk to us about that case. So Luana, can you tell us just generally, what is this case about?
So in Bostock, there were 3 employees in this case. There was Gerald Bostock, who was a county level employee. He was terminated after he participated in a gay recreational softball league, and that was reported to his employer. Then there was Donald Zarda, who was terminated shortly after disclosing that he was gay at work. And there was Amy Stevens, who was employed by a private sector employer. She first came to work and was employed as a male, but later informed her employer that she intended to transition and live and work as a female. And shortly after that disclosure, she was terminated. All 3 plaintiffs filed a lawsuit and challenged their terminations. And so the Supreme Court looked to see if there was violations of federal law.
Okay, so what law were the plaintiffs fighting under?
It's Title VII of the Civil Rights Act of 1964.
And what is Title VII?
So Title VII is a federal law that prohibits employers from discriminating against refusing to hire or engaging in adverse or discriminatory actions for any individual based on race, color, sex, or national origin.
And what did the Supreme Court decide on these cases?
What they decided was clear. They looked at the arguments from the plaintiffs and the responses from the respondents, and they determined that terminations based solely on a person being homosexual or transgender violate Title VII.
And what part of Title VII of the definition that you gave did that fall under?
So what the Supreme Court looked to see was whether or not this was a sex-based discrimination. And what they held was, yes, the sexual orientation and the sexual identity was a sex-based discrimination.
So since the Supreme Court did decide that making employment decisions or discriminating or terminating a person based on their status as either a gay or lesbian person or a transgendered person, what does this mean for employees and employers going forward?
Employers must remember that they cannot make any adverse employment decisions. They cannot hire or terminate a person or make any judgments with regards to the implementation of their employment policies based on a person's gender identity, their sexual orientation, or their gender expression. Employers are free and welcome to contact us to navigate throughout this very complex area of the law, as well as if there are employees who feel that they've been discriminated against or they have had adverse actions happen to them during the course of their employment, they also can reach out to us for help.
So is it safe to say that this is a win for the LGBTQ community?
It is. What it basically establishes is that sex-based discrimination is not allowable. A lot of times, and I do a lot of employment policies and manuals for employers, there are generalized provisions in employment manuals that says that an employer cannot or an employee cannot act in a way that is disparaging on the employer. And so a lot of times, or prior to the holding in this case, employers could use this, especially in the 11th Circuit, to terminate employees based on them being gay or their transgender.
Okay, well great, thank you, Luana.
Okay. Now we're going to move on to the Department of Homeland Security et al. Versus Regents of the University of California. So Megan, tell us a little bit about this case.
So this case is about the Deferred Action for Childhood Arrivals, also known as DACA. And this was basically a program that was instituted by the Department of Homeland Security, which the Department of Homeland Security was saying was a non-enforcement program. And all that means is that I think most people are familiar that if a person is residing in this country illegally, then the federal government has rules and regulations to remove that person from this country if they don't have a visa, they don't have some kind of document that allows them to be in this country legally. So what DACA does is it allows the children of immigrants, so basically people who were brought over here by their parents when they obviously couldn't control their circumstances. So if they were brought over to this country from another country before they turned 18 and they didn't really have a choice in the matter, then it defers action for those individuals for 2 years so that they can't be removed. And during those 2 years, then they can apply to stay here more permanently, whether for a green card or for permanent citizenship. And that's that the Department of Homeland Security said when they promulgated this program was that essentially a lot of these children were brought over here when they were very young, and this is the only home they've known, and they're essentially Americans in every way except on paper.
Okay. And so what does the term DACA stand for?
Deferred Action for Childhood Arrivals.
Okay.
It's an immigration plan, like I said, it's not a law.
And so if the Department of Homeland Security promulgated this DACA program, can they not rescind it?
Well, the Supreme Court said they could. And the University of California and the other plaintiffs in this case, who were also individuals who were recipients under DACA, as well as other state departments, were not challenging that. They weren't saying that the Department of Homeland Security couldn't rescind the program because it was their own program. All they were saying is that they didn't follow the proper procedures in order to do it.
Okay. So what does this mean, the Supreme Court case? What does this holding from the Supreme Court or the ruling from the Supreme Court mean with regards to benefits under DACA?
Well, all this ruling says is that the Supreme Court agreed with the DACA recipients and the University of California, who's actually the named plaintiff or defendant in this case. They agreed that the Department of Homeland Security did not follow the proper procedures when it rescinded this program. And one of the things was that they didn't really give proper notice to the recipients. And the Department of Homeland Security tried to say that this was just a non-enforcement policy. Like, for example, a lot of people may have heard that during President Obama's administration, he announced that the federal law enforcement agencies would not be enforcing any laws prohibiting the use, sale, or distribution of marijuana. That is a non-enforcement policy. The Supreme Court said this particular program is not a non-enforcement policy because it actually provided benefits to certain recipients of DACA. Not just that they weren't going to be removed in the country, but they were allowed to stay in the country and have an opportunity to get that proper documentation so that they could stay here more permanently. So ultimately, what this means is that while what the Department of Homeland Security has done right now is not correct, that doesn't mean that in the future the Department of Homeland Security can't remove this program. It's just the way they did it to this point was incorrect.
Okay. Now we'll move on to the case of Little Sisters of Poor Saints Peter and Paul Home versus Pennsylvania et al. Can you tell us a little bit about that case?
Sure. This case is a little bit similar to the Department of Homeland Security case dealing with DACA, and it was whether a federal agency could promulgate its own rules or make its own rules. This particular case this particular issue has kind of been going on for about 10 years. When the Affordable Care Act was implemented during President Obama's administration, the Department of Health, the Federal Department of Health, made some regulations which required employers to provide certain benefits for women, which included preventative care and eventually included contraceptives. Well, certain religious organizations, such as churches, believed that that violated their rights and their right to religious freedom, which is a constitutional issue. And the Department of Health agreed with that, and therefore made a rule that said, that basically became known as the church exemption. So a church would not have to provide contraceptives to any woman because it violated their religious beliefs. Well, after the church exemption was implemented, then other religious organizations that aren't necessarily houses of worship said, well, wait a minute, this violates our religious freedom too. So organizations, charitable organizations, such as maybe like a Christian homelessness organization, while they're not a church and they're not providing religious services, they're faith-based, and providing contraceptives to women violated their rights, according to them. So the department went back, looked at its rules again, and said, okay, we're going to require a self-certification for nonprofit religious organizations who want, who believe that having to provide contraceptives violates their rights. So then, after that, everybody may remember the Hobby Lobby case that came out about 2015. Hobby Lobby said, whoa, we're a for-profit organization, but this violates our morals. We who own this company, we are religious, and we believe that having to provide certain contraceptives to women violates our religious beliefs. And so then that went through the courts, and essentially the Supreme Court decided that if they did hold that moral belief, that it did violate their religious freedoms to have to provide those contraceptives. So what this case essentially deals with is similar to the last case, in that the department basically rescinded or implemented those exemptions.
Okay.
Well, we appreciate you watching today. We hope we've helped you learn a little bit about the busy Supreme Court session that we just have. We hope you have a great rest of your summer, and we're looking forward to the next Supreme Court session where we can update you again.
Thank you.